everyone. We're back. Let's go on the record. We had 5 matters scheduled for preliminary examination this afternoon. One of the matters, John Shook, we had dealt with this morning with Mr. Tim George and Angelique Camfield. That matter's been adjourned to December 16th. Jacob Vaughn filed a waiver, and that matter is resolved, and Julia Westcombe also signed a waiver. That leaves us with 2 cases involving Mark David Duchalier. So I'm saying your name wrong, and you told me last time, but you say it for me?
Duchalier.
Oh, I wasn't very close. Duchalier. All right, the first case in time is August 8th. That's 251935. And that alleges a larceny of building in Three Rivers at a downtown store on North Main Street. File 252138 FY alleges an October 16th incident at the Walmart store in Three Rivers. Each of these is charged as larceny of building. The defendant is charged with larceny of building as a habitual offender. There's a plea offer that was valid until today. It appears from the affidavit of probable cause, there is a video of each of these proceedings. And we were here last week, and the matters were set for prelim this morning, or for today. Mr. Gibson stepped out for a minute, and the defendant indicated to me that he wished to adjourn this because he wanted to hire a lawyer. And I said, well, let's wait till everybody gets here and then discuss it. Now that all the witnesses are here, Mr. Duchalier, what would you like me to know?
I wish to hire an attorney, Your Honor, at this point in time.
You have to speak up.
I would like to try to hire an attorney, Your Honor.
Have you talked to anybody?
I've currently been looking into it.
That means no,
I've looked into it.
but you've not actually talked to any attorney?
I talked to one of their secretaries.
Okay.
Well, the lady at the front desk. Clerk, I guess it would be.
Now, as I mentioned, each of these matters, according to the affidavit, there's a video of it. Before court started, Mr. Robert came in to meet with Mr. Gibson and provided him apparently screen captures of some videos, one from the store on Main Street and one from Walmart. And have you had a chance to watch the videos of either of these proceedings?
No, Your Honor.
Before 2 minutes ago, did you see the pictures of each of these cases?
Yes, Your Honor.
All right, you'd seen the pictures before today?
Yes, Your Honor. No.
Oh, so the first time you saw those pictures was a few minutes ago?
Yes, Your Honor.
And those pictures purport to have you in them. They came from 2 separate videos. You haven't had an opportunity to view those videos. Mr. Gibson, have you had an opportunity to view the videos?
No.
Why not?
I'm not sure that I had determined if there was any digital evidence available in my discovery material, but I had received written police reports that I had obviously gone over with the defendant and affidavits, but a lot of times we don't always get digital evidence until maybe the case is into it a ways after it's found over. But sometimes I'll get that kind of stuff immediately. Sometimes it comes in like a few weeks later. So
Your Honor, I can see that we have the digital evidence on the case that happened at Main Street Ladies Gym. That's been provided to defense counsel through the Axon account at the end of October. It's like October 31st. We don't have the video from the Walmart incident. And that's what I provided him today, the loss prevention report with screen grabs of that. So he could have, his client could have watched the video in the other incident.
I don't know much about the cases at this juncture because I'm not supposed to know too much. As we get into sworn testimony, I hear more about it. But there is an affidavit of probable cause. Which states there is a video of the suspect from Walmart. They provided the video and Duchalier was identified from the video of the suspect. I wouldn't wait till after there was a prelim or after the matter was bound over to look at the video. If I was the defendant, I would say, I want to see the video. This is embarrassing. In the 27 North Main Street, the ladies' gym, it says in the affidavit of probable cause, she received video footage of a suspect coming into the building. I compared a SOS photo to the video footage. It's the very first thing I would have done is got the video footage and watched it with my client. Mr. Robert, I apologize because you brought the witnesses in here and Miss Ward is here and the people are here from Walmart and you're ready to go. But the defendant wants to hire an attorney. There may be an ineffective assistance of counsel issue if I don't grant it. They haven't bothered to get the video evidence or look at it. So can you disclose who it is you're considering hiring?
Not yet, Your Honor.
Are they from Michigan?
Yes, Your Honor.
All right, now we show a South Bend address for you. You've attended every hearing. Where do you actually live?
My house is in South Bend. However, I've been living here in Michigan.
All right, where do you stay?
I'm transitioning to Michigan now.
All right, I think that's what you told me before. You have permission to live in the state of Indiana and you've attended every hearing. So there's that. The only regret I have is these people got subpoenaed. They took time out of their day to come here. But my fear is if we proceed, the whole thing could get undone. And then your new attorney's gonna say, well, I can do the case, but I can't do it on that day.
If anything, Your Honor, and
Yes, sir.
if possible, we can move it for 2 weeks out, and if not found an attorney by then, I'm more than willing to represent myself pro se.
Well, I'm not a big fan of that, but one thing I would be a fan of is you having an opportunity to watch the video of each of these incidents. The police contend that it's you, and there's not much dispute to the fact that it is you. Well, you ought to be able to see it.
When he was interviewed by Detective Smelcombe, he identified himself as the person in the video. He was shown stills.
All right, so it's not a whodunit.
Excuse me, Your Honor. I was never shown a video.
All right, well,
Nor did I identify myself as anybody. So
Okay,
that's a false
again,
statement.
I'm not supposed to know too much. But there's two videos that Detective Smallcombe says, those are you. I guess you might want to have a chance to view them because there's a plea offer that the prosecutor has made, which affects your sentencing guidelines. And if you have a preliminary examination, the plea offer is withdrawn. And if you are convicted, the sentence would be different because the habitual would be on there and the sentencing. Has anyone reviewed what the sentencing guidelines would be between the current status and the plea offer?
Nothing.
Your Honor, I don't think it's necessarily fair for what this necessarily is hearing, because the defendant is not necessarily being totally open with you about. I attempted to talk with him about this case numerous times, and he was very hostile toward me and acted like I didn't work for him, and he didn't want to talk with me. So a lot of these things I never could really even get into him because he wouldn't even allow me to have a conversation with him. He just was telling me that, how much I don't know, he was not polite with me. He was not wanting to listen to me, and he constantly cut me off and wouldn't let me talk.
So you never got a chance to have an in-depth discussion with him regarding the plea offer?
Well, regarding the plea offer or regarding the facts of each case?
Any of it. Well, one of the things that should be done, as far as I'm concerned, is when there's a plea offer, the defendant ought to know the difference between the sentencing guidelines on the offered charge and the case without the sentencing guidelines. And I don't know that they always do that. I don't know that anybody does it. Some of the lawyers do. Anyway, the bottom line is, I apologize, Mr. Smallcombe, Ms. Ward, and Mr. Robert. We're going to have to adjourn this for 2 weeks. Give the defendant an opportunity to. Mr. Gibson is not working against you. He is who's been appointed to represent you. You had a right to hire a lawyer right out of the gate. Well, you didn't. You asked me to appoint a lawyer for you, so I did. So the prosecutor shares the police reports and the information with him. That information should, or at least before I made a decision about waiving the prelim or holding it, have the video in it so you can see it. According to Mr. O'Barry, you even said it was you. I'm not taking away your right to have a prelim. If you want to have a prelim in each of these cases, I'm willing to do it. Now, let me repeat. In a preliminary examination, you don't get found guilty or not guilty. They just determine whether there's sufficient probable cause to believe that a crime was committed and that you did it. Well, the owner of the store is going to come in and say somebody came in and stole a bag full of money. Well, that's pretty clear probable cause. The question becomes whether there was probable cause it was you or not. Probable cause is a lot less than proof beyond a reasonable doubt. It doesn't take a lot for the court at the district court level to find probable cause. The matter then gets bound over to circuit court, and you have a right to have a jury trial in front of 12 people that would have to find beyond a reasonable doubt that you did it. And that's not always that easy to do. The difference here is there's a difference in the plea offer between whether you waive the preliminary examination or hold a preliminary examination. If you hold a preliminary examination, the plea offer is withdrawn. And if you are convicted in circuit court, it changes the sentencing guidelines, makes them higher. So and as a layperson, you aren't going to know that. You don't know how to read the sentencing guidelines. You don't know the rules of evidence. I strongly suggest you either stay with Mr. Gibson and cooperate with him and watch the videos, or you hire a lawyer of your own choosing, and then you can do whatever you want. But I'm not a big fan of having you represent yourself. 2 weeks from today, would be December 2nd. Let's see how bad that is. I have a funeral in the morning. we could bump this to Tuesday, December 2nd at 2 p.m. Both cases.
Did you say at 2 p.m., Your Honor?
Yes, I have a funeral at 11,
Okay.
so
just
I
wanna
may
make
be
sure.
to December 2nd.
It says that I have a prelim at 1 o'clock that day. I don't know if that would be in a different court,
No, that's me. I'm the prelim judge that
Okay.
day.
but it also looked like that was at one point that was a circuit court trial date for me, but I'd have to check, but I believe those all may have been resolved or adjourned.
Let's see here. Nobody's available. They're probably on the bench. I'm going to continue this to December 2nd at 2 p.m. If he hires another lawyer, Mr. Gibson, it won't be your problem. If he continues to be your client, then it could be. But Mr. Duchalier, I'll get it right eventually. It's not in your interest to fight with your lawyer. He's paid to represent your interests. But I would encourage you to get a chance to view these videos and to understand the difference in the sentencing guidelines between the plea offer and the not plea offer. Either way, I think we're constrained to adjourn these matters, whether we wanted to or not. So both cases are continued to December 2nd. Ms. Ward, do you have a problem with that date?
Sorry.
December 2nd, is that a day a problem for you?
Yeah, that's fine.
Okay. All right. Well, your bonds are continued. All the conditions that are in there remain in effect. You may reside in the state of Indiana. If you are going to hire an attorney, they know what to do. They get a substitution from Mr. Gibson and they file an appearance. And Mr. Gibson can either turn over all the evidence he has to your new attorney, or they can get it from the prosecutor. But I would encourage you to do those two things. Watch both videos and determine what the sentencing guideline difference would be between the plea offer and the not plea offer. All right, Mr. O'Bear, anything to add?
I'll just add, it looks like a new complaint was authorized on this defendant today, so it's working its way through the system for felonious assault.
Well, you may want to bear that in mind as well. All right, at any rate, this matter is set in front of me for December 2nd at 2 p.m. in both cases, 2 file 1935 FY and 252138 FY.
Thank you, Your Honor.
Thank you.
We are on the record in the 13th Judicial District, the District Court of Greenwood County, Kansas. Case number GW 2025 CR 102, State of Kansas versus Aaron Wilbur Dye. Please announce appearances.
May it please the court, this state appears by Jill Gillette, County Attorney.
Your Honor, Mr. Dye appears by Zoom from the Greenwood County Jail, as well as Jorge De Hoya is here by Zoom, his attorney.
This matter does come on for preliminary hearing. Are the parties ready to proceed?
The state is, Your Honor.
The defense is, Your Honor.
All right, please call your first witness.
Your Honor, we'll be calling Deputy Blake Fisher.
Please raise your right hand. Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, and Deputy Fisher, is there any way you could kind of lighten your screen a little bit?
It's gonna get lighter over time. It takes it a minute.
All right,
I don't know why it's doing this, but it'll get lighter.
all right. Well, then let's, if there's no objection, we'll go ahead and proceed. Okay,
Yeah, no objection, Your Honor. Thank you.
I know your color's fine. That's curious how that worked, but now you're looking really good. Gillette?
Could you please state your name for the record?
Deputy Blake D. Fisher
And how are you employed?
by the Greenwood County Sheriff's Office.
How long have you been so employed?
since December of 2019.
And were you on duty on June 12th of 2025?
I was.
And were you attempting to serve civil processes that day?
I was.
What address did you go to serve civil process on June 12th, 2025?
I believe it was 211 South Elm Street in Eureka, Kansas, Greenwood County.
And who were you there to serve?
Aaron Dye.
And did you note anything when you went to serve at that address?
As I was knocking on the front door of the residence, I was able to smell the odor of marijuana emitting from the doorway.
And were you able to get in touch with anyone in the residence?
Not at that time, no.
And what did you do next after trying to get a hold of someone?
I contacted Sergeant Cordell via radio traffic, asking him to respond to my location to sit on the residence while I applied for a search warrant.
And did you, in fact, apply for a search warrant?
I did.
Was that search warrant granted?
It was.
And did anyone else arrive to assist with the search warrant besides Sergeant Cordell?
Deputy Oakley.
And did you end up making contact with someone in the residence?
I did. Leonard Airy.
And did he end up opening the front door?
He did.
And once he opened the front door, what was the next thing you did?
I instructed him to exit the residence, and he complied. I asked him if there was anybody else inside the residence. He said his nephew was.
Okay. And who was the nephew?
Jeffrey Airy.
And then did you end up finding Jeffrey Airy?
I did.
Where did you come across him at?
He was downstairs in the residence.
And were you able to identify the bedrooms within the residence?
I was.
And did Jeffrey help you identify whose bedrooms were whose?
Judge, I'm going to object. I don't see Jeffrey Airy on screen at all.
He is. He's the one in the blue shirt under T. Husier.
Oh, forgive me.
Withdrawn.
Mm-hmm.
Please.
Go ahead.
Did Jeffrey Airy help you identify the bedrooms?
So it was Leonard. After I cleared the residence, I walked outside. Sergeant Cordell informed me that Leonard had been provided with his Miranda rights. I asked Leonard who the first bedroom belonged to in the residence. As you walked in, he claimed ownership of the first bedroom. And I asked who the second bedroom belonged to, and he said that was Aaron Dye and Misty White's bedroom.
And is there a relation between Leonard Airy and Misty White?
They're siblings, I believe.
And did Jeffrey identify his bedroom?
Yes, as being in the basement of the residence.
Okay. And when you conducted the search, did you search the bedroom belonging to Mr. Dye and Ms. White?
I did.
And what, if anything, of evidentiary value did you find in that room?
So as I was searching Leonard Airy's bedroom, Sergeant Cordell was searching Misty White and Aaron Dye's bedroom. And at the time, he found a plastic baggie with crystalline substance in it.
The judge, I'm going to object to a foundation here. The deputy just admitted he was not the one doing the search and cannot speak to what was found on that search.
He can say what was relied to him, and Sergeant Cordell's here as well.
Allowed in that fashion.
So after the different searches, did you end up going in to help with the Dye and White bedroom?
I did.
And were you the primary affiant to write the affidavit in this case?
I was.
Now, when did you conduct any interviews with Aaron Dye?
No, not at this time. He wasn't on scene.
And what, if anything else, did you discover was within the house?
Judge, I'm
Um,
going to object to relevance. We're not here to discuss everything found in the house. We're here to discuss what is attached to Mr. Dye's case.
Was there anything in any of the common rooms?
There was empty plastic baggies and digital scales with residue that was found in a drawer with men's clothing inside Aaron Dye's bedroom.
Judge, I'm going to object to that question as the answer is non-responsive. The question was not about Aaron Dye's bedroom. The question was about the common areas.
Sustained.
Was there anything in the common areas of the home?
Not that I can recall at this time.
Okay. And was Jeffrey Airy residing within the home where the methamphetamines were found?
Yes.
And is he under the age of 18?
Yes.
And do you recall when his birth date is?
It is in 2009. Ending in 2009.
So would it have, how old would he have been at the time that you did the search warrant?
Was that, I don't know, 16? I don't know. I'm not good with my math. I just put the birth date in.
Okay. Judge, we can note that September of 2009 is his birth month and year. And that and had he had his birthday yet that year in June, Deputy?
You said what now?
Had he had his birthday yet in June?
No.
Okay.
His birthday's in September.
All right. And when you were packaging, weighing, and interacting with the substances found throughout the entire residence, did you find any drug tax stamps on any of the items in the residence?
No.
Did you submit these items to the KBI lab?
I did.
Your Honor, the state will move to admit the KBI lab for purposes of the preliminary hearing. We've already sent a notice that we will be using it for preliminary hearing, and for purposes of preliminary hearing only, we've moved to admit the KBI lab report into evidence.
Mr. De Hoyos, any objection?
I don't think I have any proper grounds for objection here, Your Honor.
All right, admitted.
And Your Honor, we'd ask if Missy has that, if she would please place it on the screen as states 1.
Missy, do you by chance have access to that today?
Yes, I do.
Okay. You can put that on the screen if you want, if you would, please.
I would note for the court that the methamphetamine, one bag weighs 10.40 grams. And methamphetamine in lab item number 2 was positive for meth. And the item 3 was positive for methamphetamine, which was the digital scales. And then there was a burnt cigarette piece that was positive for THC.
And could you link those up to where they were found according to the officer's testimony?
Yes, we can do that now. Deputy, where was the large baggie of methamphetamine found?
That would have been in Aaron Dye and Misty White's bedroom.
So Judge, I'm gonna object here because as I recall the testimony, Deputy Fisher was not the person who searched that room.
Right, but Deputy Fisher is the affiant officer and he can relay what was relayed to him so far as the hearsay witnesses are present and available to testify, which would be Sergeant Cordell.
I don't disagree with you. I just need the judge to make a ruling on the same for the record. That's all.
All right, I'm going to sustain that objection, but I think, Ms. Gillette, you can ask questions to clarify.
Did Sergeant Cordell bring you the larger bag of methamphetamine from Aaron Dye in Misty White's room?
He notified me that he found it, yes.
Okay. Then did you help collect that bag from that room?
Yes.
And again, Sergeant Cordell is here to testify, right, Ms. Gillette?
He is.
Okay.
He's bottom of my screen. I don't know where he's at in
I
yours.
see the screen. Sergeant Cordell, are you here?
Yes, ma'am.
Thank you, sir. Please proceed, Ms. Gillette.
And where were the two smaller plastic bags found?
I believe those were in the same bedroom.
Okay. And where was the digital scale with residue found?
In the same bedroom.
Your Honor, I will pass this witness.
Okay, thank you. Cross-examination, Mr. De Hoya.
This is Mama Judge. Just want to read something real quick here. Officer Fisher, the warrant you received, did it qualify whose bedroom was whose whenever you received it?
No.
Okay. Did you seek permission explicitly to search Aaron Dye's room through that warrant?
I asked for the permission of the whole residence and surrounding curtilage.
Okay. But there was never anything specific or narrowed enough to identify whose bedroom it was and whose bedroom was granted by the search outside of the general scope of the house. Is that right?
There was nothing that specified whose bedroom. I wasn't told whose bedroom was whose until after the search warrant was opened.
Okay. And at the time that you became aware that the bedroom did not belong to Leonard Airy, did you reapply for a new search warrant?
No.
Did you seek out anything more specific in the search warrant to adjust for the different ownership of the rooms?
No.
Okay. No further questions of this witness, Judge.
Can you redirect Ms. Gillette?
No, Your Honor.
All right, thank you, Deputy Fisher. Any reason why Deputy Fisher should not be released from his subpoena, counsel?
We just ask you stay in case we need rebuttal.
All right, then I'll have to ask you to do so, Deputy Fisher.
Your Honor, we will call Sergeant Cordell.
All right, Sergeant Cordell, if you'll rejoin us. Do you solemnly, please raise your right hand. Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right, thank you. Please proceed.
And Sergeant Cordell, could you please give us your full name?
Sergeant Mike Cordell,
How are you employed?
as a patrol supervisor and canine handler for the Greenwood County Sheriff's Office.
And Sergeant, were you called to the scene that Deputy Fisher had for a search warrant?
Yes,
Did you sit on the house while the search warrant was being applied for?
I did.
Was there anyone that came or went during the time that you were watching the house?
No,
And did you assist in the search once the house was opened?
yes, I did.
Did you search one bedroom while Deputy Fisher searched the other?
Yes,
Which bedroom did you search?
I searched the bedroom that we ultimately determined belonged to Aaron Dye and Missy Crawford.
And there was numerous items found within that room. Can you tell us where you found the large bag of methamphetamine at?
Yes, so there was a nightstand on both sides of the bed. The one to the left side of the bed as you're looking from the doorway of the room. So at the foot of the bed on the left side would have in that nightstand is where I located that bag of methamphetamine.
And Where did you find the smaller bags that had residue in them?
Those were in drawers in dresser, which would have been from that same perspective, the opposite side of the room.
And where was the digital scale?
Also located in that dresser along with those bags.
And were there any other items that were found within that bedroom?
There were numerous items which had the names of both Misty Crawford and Aaron Dye on them, including on the same side of the room as the scale in the bags. And there was a spoon with burnt residue, and I believe a syringe. All of those items were located on that same side as the scale in the bags, and there was also a certificate with Aaron Dye's name on it, which was in a frame on that same side of the bed.
And were there both men and women's clothing in that room?
Yes.
And was there any mail or other items besides the certificates and numerous items with their names on it within that bedroom?
There was mail, yes.
And was there anything else in that room that would have been of evidentiary value besides the items with their names and the methamphetamines and paraphernalia?
Not that I recall. I wasn't there the entire time. I did actually leave when a van that appeared to be identified as or similar to the description of the one that they were driving had passed the scene and kept on driving. So I left at that point to go try to find them.
Okay. And did it end up pulling in down at a different location?
Yes, the van drove past us and then went and parked in a driveway at a house several blocks away.
Okay. And do you recall who was in that van?
So I made contact with Misty Crawford via telephone. Mr. Dye didn't answer his phone. I had her walk back to the residence where I placed her under arrest. I then located that van at a later time in a driveway at 303 South High, but it was empty at the time that I located it.
All right. I will pass this witness to the defense.
Cross-examination.
Judge, I need just a moment here.
Very well.
Sergeant Cordell, it's Sergeant, right?
Yes,
Sir, did you create a police report in these matters?
I did type a supplemental narrative. Yes.
Okay, and did you provide that to the prosecutors?
It's in the file at our office. I would have been sent over with the rest of the reports.
Okay. Judge, if we could take a moment from the, just a pause from the witness. I don't believe I have any reports from Sergeant Cordell, and 223213 entitles me to the same if he testifies.
Ms. Gillette, do you have any, do you have that report in your file that
I don't have it in my paper file, but it could have been added after we print it. So we send a digital link now. So everything in the sheriff's office file that comes to me actually goes to the defense attorney through the electronic evidence library. But sometimes supplemental reports come in after the fact. And so it may have been added to the queue. I haven't looked in there to see if it was added extra after.
Judge, I'm digging through all my stuff. I just don't have anything with this officer's report in that.
I was going to look real quickly at the affidavit from Deputy Fisher and see if it was filed in attachment to that. It looks like what was filed in the affidavit is strictly from Deputy Fisher. So how do you want to proceed, Mr. De Hoya?
Well, Judge, because I'm entitled to the same, I want to have a copy of that prior to engaging in the cross-examination because I cannot effectively cross-examine without it.
All right. Would it be sufficient if we have Ms. Gillette text or faxed you a copy of that. And then, if you
Yeah, I
have-
mean, if she
if that's the
emails
time
me
to
right
look over.
now. Yeah, if she emails it to right now, I won't have an objection. I just need to be able to see it.
Ms. Gillette, can you email him a copy of the Cordell?
I'll have to look and see that I don't have it in my file. If it's in the evidence library, it would already be available through his link.
I can send it to you, Jill, if you need.
Okay.
It was,
So we could kind of try to keep things going if at all possible.
I gotta pull it up here. It was completed July 26th of 25. I've got it right here. I'll send it to you right now.
All right, probable cause of affidavit was filed June 17th, so that would have come in much later.
Officer, I've received your report and I'm grateful that you forwarded the same over to Jill. Thank you for that.
Yeah, no problem.
Were you wearing a body camera at the time of this search?
Yes.
And have you provided the same to the prosecution?
Yeah, the body camera would be uploaded to our evidence library, and that body camera footage would be a part of that link that has everything that's part of the case.
I don't have that yet, Jill, but I'll get with you later to see if we can find that. I know for the purposes of today, it's not necessary. Okay. You said that you found the bag of methamphetamine in a nightstand on one side of the bed. Is that correct?
That's correct.
Were you able to identify who slept on that side of the bed?
That appeared to be Misty Crawford.
Okay. So would it be safe to say, based upon your review of the scene, that that was Misty's nightstand?
I would agree that that was Misty's nightstand. Yes.
Okay. And that was the actual crystal methamphetamine found in the house. The rest is concerning residue or other apparatuses. Am I right?
Yes. So the paraphernalia, which I believe was charged as paraphernalia for distribution, and the other smaller quantities of methamphetamine were in other locations. The largest quantity was in that one bag. Yes.
And you'd mentioned some kind of certificate with my client's name on it?
Yes, there was a certificate in a frame with his name on it.
Do you remember what the certificate was?
I believe it was a certificate that was certifying him as some degree of drug counselor, something like
Okay.
that.
And your body camera would reveal anything about that, or would show us what you were looking at?
Yeah, the irony of it was pointed out on body camera. So
Did you say the irony of it was pointed out on body camera?
absolutely, that was the first thing I noticed was how ironic that certificate was.
I love these hearings. They're never boring. Okay. But to be clear, you want to identify the nightstand as Misty's. The bag inside there was a Misty's thing, and the certificate was on the other nightstand, separate and apart from Misty's stuff.
It was on the other side of the bed. It wasn't on the nightstand. I believe that was actually due to the construction of the bed. I believe it was like on the bed, but like under the, I believe it was like on a platform where the mattress was sitting. But yeah, it was on the other side of the bed.
You searched the nightstand that we could identify as Aaron Dyes at this time, right?
I did.
And what did you find, if anything, in it?
I don't recall anything in the nightstand. I do recall finding items in the dresser immediately adjacent to the nightstand, but not in the nightstand itself.
Okay. But in the dresser, you found mixed clothing, men and women?
Yes, there were men's clothes in some drawers, women and others. Yes.
Okay. And the paraphernalia you found in that dresser, you found that in women's clothing?
I believe the scales and bags were located, and the burnt spoon, I believe, were located in men's clothing.
And you didn't capture a lot of details about that in your actual report, or your written report, forgive me.
No.
So it's really the body cameras that need to be reviewed for the purpose of determining that. Am I right?
Yes, and I that's prior to a hearing. That's had I remembered this hearing was today, I probably would have reviewed that. But prior to any further hearings, that would be my preference is to review my body camera.
Okay. Judge, I don't have any further questions for this witness, and I appreciate both Fisher and Cordell being available to us this morning.
Okay, Ms. Gillette, any redirect?
Just a little bit. So the dresser contained what kind of clothing?
There was men's and women's clothing, but mostly men's, I believe, and the drawers which contained the paraphernalia, I believe, also were men's clothing.
And besides the digital scale that was in there that had residue, what else was in there?
I know there was numerous empty plastic bags, and then there were other items of paraphernalia for use, but I don't recall the specific items.
That's my only redirect, Your Honor.
Recross.
Just briefly, the warrant itself was for the search of marijuana.
The warrant was, I believe, for the search of illegal drugs, including but not limited to marijuana, I believe.
Yeah, nothing further on that, Judge. Thank you.
All right, Ms. Gillette, you may call your next witness. May Sergeant Cordell be excused, or do you want to keep him for possible rebuttal, Ms. Gillette?
Judge, I believe the state will rest at this time.
All right, thank you. And Sergeant Cordell, Deputy Fisher, you're welcome to stay or go unless you've been subpoenaed by the defense. And Mr. De Hoyos, do you have any evidence you wish to proceed?
And Judge, just for the record, his report was uploaded July 26th of 2025. The evidence link was sent July 22nd of 2025, so it would have been in the original stuff 4 days later.
Okay. All right. Well, I see we have about 3 other witnesses, but you don't plan to call them, Ms. Gillette. Mr. De Hoyos, you don't plan to call them?
I think most of it would be hearsay and repetitive as to who's was whose.
Yeah, I think Jill's done a great job to make sure she has who she needs in the event that there was a hearsay objection or a foundation objection, but I have no intention of calling those witnesses or any other witnesses. The defense provides no evidence at this time.
Okay. Are there any arguments to be made at this time from the state?
Your Honor, the methamphetamines is in the bedroom of Mr. Dye and Ms. White. It is in a nightstand. They both would have access to anything within their bedroom. It was obviously not locked because officers were able to access it. The digital scales with the residue and the numerous empty bags and other paraphernalia that would have been used for distribution were in the dresser with the men's clothing. And that was all within their bedroom. There was a minor child in the house that would have been 15 years of age at the time. And there would have been the possession of 10.40 grams of methamphetamine, along with all the distribution items in that same house with that minor child, as well as all of the drugs that were found in Mr. Leonard Airy's room. There was no drug tax stamp found on any of the drugs. And there were other items of paraphernalia that tested positive within the room that would be the level 5 possession of methamphetamine. We'd ask that you bind the defendant over on all charges.
Mr. De Hoyos, any argument?
Just a moment, Judge. Judge, I don't know that there's any direct evidence that the defendant possessed that 10 point whatever grams of methamphetamine. I think that there's evidence that Misty White did, and Misty White had it in her nightstand. But I think that, you know, at best, the state is reaching for constructive possession here. Outside of that, I don't know that we actually laid the foundation for aggravated endangering a child. And the reason why is because you have to expose to the manufacture or sale of meth. There's no financial anything here to recommend it. And what the state is wanting you to do is make a jump from, hey, if there's enough meth in the house, it must be manufactured or sold. And while the presumption of distribution may apply to the amount of methamphetamine found in any one location, that presumption has not been case lawed into, also presuming this sale for the purposes of aggravated endangering a child. More than that, Judge, it sounds like the child was in the basement, separated from anything located at missing errands. An argument that, you know, things weren't locked, I think goes only so far as whether or not you have demonstrable ability to go in the room, permissions to go in the room. Just because I have methamphetamine in my hotel room does not mean every child that walks in that hotel is suddenly an aggravated endangering a child claim. So in the same way, the state has just failed on that count. I think that the rest of these can be found probable cause by way of the standards here today.
Well, I have been troubled about the evidence or lack thereof on number 4. I didn't hear any evidence that the meth was manufactured in the home that the child lived in. I didn't even hear any evidence that there was any sale of meth going on or fentanyl. It says sale of meth or fentanyl. I didn't hear any evidence that it was actually being sold there. There was some baggies. There was a scale. So I suppose you could say, well, they were measuring it and going to go sell it somewhere, but of course this isn't. The test in this case is probable cause based on the evidence, not on speculation. They could have been possessing that with the intent to go sell it down the road somewhere, not near this child. So I think that we lack probable cause on count 4, and I do not find the defendant over on that. But I believe the state has met its burden on the remaining charges, and I bind the defendant over on the remaining felonies based on presumptions and other laws. So he's bound over on count 1, count 2, 3, 5, and then 6 is a misdemeanor. So everything but count 4, basically. It is troubling that the child was in that kind of a home, but I don't believe it meets probable cause for manufacture or sale and with the child around. All right, so let's see, Missy, who's the arraignment with?
Let's set this one over with the other case for Judge Crum on November 26th at 9 a.m.
So he has another case with Judge Crum is that for arraignment also?
Yes, it is.
All right, that's what we'll do then, counsel.
Thank you, Judge.
Okay, thank you.
Thank
All
you,
right.
Jill. Thank you, officers.
All right, we'll be in recess at this time.
Wait. I missed the court date. I'm sorry.
26 at night.
November 26th at 9 a.m. I understand he has another one with Judge Crum at that time.
Yes,
For arraignment.
failure to register case.
And then one other question. This hearing, what case was it over?
This was 25 CR 102.
All right, thank you.
Thank you. Again, we are in recess.
All right, let's go on the record in the matter of the state of Michigan versus Crystal Zamorski, 251612, and the state of Michigan versus Crystal Zamorski, 251614.
Good morning, Your Honor.
Okay, go ahead, counsel.
Do we have to do a reading first from the officer?
Well, yeah, so I thought you were trying to put your appearance on the record. Okay, just good morning. All right, and so detective, your name for the record, please.
Oh, thank you, Your Honor.
Okay, very good, thank you. All right, your name for the record, please.
Detective Joseph Carwine, Police Department.
All right, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you. And you may proceed on the warrant.
Your Honor, on November 15th, 2025, Officer Carpo was reported that she was dispatched to 1110 Sycamore Street regarding a larceny complaint. Officer Carpo reported that she arrived at the address and spoke with the victim, identified as a Dana Jakubiak. Officer Carpo reported that the victim stated that on 11:13, she noticed the gate located in the west side of her home to be unlocked and open, which was unusual. Officer Carpo reported that she checked her home security video and discovered that on 11:13, about 12:30 p.m., an unknown white female, later identified as defendant, Crystal Zamorski, is seen unlocking the gate and entering the yard and subsequently stealing items from a parked, unlocked travel trailer, which was located in the backyard. Officer Carpo reported that the victim showed her several home security videos where she observed and immediately identified the white female as the defendant from several prior police contacts. Officer Carpo reported the defendant is seen arriving at 1110 Sycamore with no shoes on and what appears to be a shorts or no pants. And a short time later is seen leaving via the same gate, wearing black boots and carrying a black bag, which was identified belonging to the victim. Officer Carpo reported she reviewed additional home video from the address, which showed the defendant running in front of the home, wearing the black boots and carrying the bag. Officer Carpo reported that the victim had checked the backyard and camper area and discovered items stolen from the camper and damage to the garage. And, the items stolen include a pair of black hunter boots, a Nintendo gaming console, Amazon Fire Stick, and this gate locking mechanism. Officer Carpo reported that she checked the defendant's status in Lean SOS and discovered that she had an outstanding warrant on the 27th District Court for a weapons offense. Officer Carpo and Kyle Cox arrived at the defendant's address located at 974 Eureka Road and made contact with her, where she is subsequently arrested on the local warrant and on the larceny. I spoke with the victim in the case the next day, and the reported items stolen appeared to be over $1,000, but less than $2,000, or excuse me, less than $20,000. And the damaged property appears to be over $1,000 and less than $20,000. And Your Honor, may I note that the defendant is also a second offense notice, which indicates that on October 10th, 2019, she was convicted of a felonious assault in the Third Circuit Court in Wayne County.
All right, thank you. Upon examination of the complaining witness, I find the offense charged were committed and that there's probable cause to believe the defendant committed those offenses. Counsel, your appearance, please.
Good morning, Your Honor. Christopher Shemp, appearing on behalf of my clients. Time and consent to the matter being heard via Zoom.
Thank you. Ms. Zamorski, your name for the record, please.
Yes, good.
Okay. And counsel, you're on the felony matter as well as on the assault and battery matter from November 13th. As to the arraignment on those matters, what are you requesting?
We waive formal reading. My client stands mute.
All right, the court will waive the formal reading. As to 251612, the court will enter plea of not guilty, schedule this matter for pretrial on November 25th. 1:45 p.m. And ma'am, you do have, as to the felony, you do have the right to have an attorney. If you cannot afford one, you may have one appointed to represent you. In fact, you've had the opportunity to speak to an attorney today, correct?
Yes.
All right, the court's also signed the petition order for appointing an attorney for felony matters as well. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury. You also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights?
Yes.
All right, the court's entering a plea of not guilty on your behalf on the felony matter, scheduling this matter for probable cause conference November 25th at 1:45. And as to bond counsel.
Your Honor, my client was gainfully employed. This arrest might jeopardize that. But that being said, she indicates she will come to any and all future court dates. She will comply with all provisions. I know financially she would have a difficult time coming up with a monetary amount, so we would ask consideration for any leniency this court could consider when determining an appropriate bond. Thank you, Your Honor.
Okay, so ma'am, you're currently on probation, right? Out of the Third Circuit Court because you failed to complete probation. There's a warrant for your arrest. Is that the issue?
What is that? I'm not on probation at no Third Circuit Court.
No?
No, ma'am.
Are you on probation in this court?
No, I did drug testing for you and I passed every drug test that you asked me to do. And on my jail review, I talked to the probation lady and I was currently in the hospital and I emailed you guys the paperwork. I called and I didn't get no return phone call regarding that. And I still have the paperwork. If you need that, I can get that.
What's that? Okay, hold on. Detective, what's the warrant, that is pending for Ms. Zamorski?
Your Honor, that is out of our 27th District Court. It looks like a weapons offense.
For jail review. And I was in hospital that day.
Okay, hold on, ma'am, hold on. Can you pull that one out, please? That must be the one from April.
It's dated, issued on the 21st of October of 2025, Your Honor, so.
Okay. Do you have that file?
I didn't hear, I was walking over here. She's on jail leave.
I know. Right, I need the file. Can we get the file since she's already in custody?
And there's her note.
Is the offense date from April, Judge?
Yes.
Yeah, it's in yours. She failed to appear for the jail review October 20th.
I talked to Natalie Shaw and I let her know that I wasn't being in the hospital.
No, ma'am, you emailed October 24th. And you didn't submit any paperwork. And as far as the email goes that you're addressing. And so then you were notified you needed to either post bond. And if you post a bond, we'd recall the warrant, or you could walk in. You didn't do that.
I did email. I don't know if it didn't go through or not, but I guess I did do that.
You're not listening to what I said. You're not listening to what I said. Yes, you emailed October 23rd. And then I reviewed the email. You didn't attach any proof of being in the hospital. In fact, all you said on here was that you were sick. In fact, I'll read the email, ma'am. Yes, my name is Crystal Zamorski. I had court the 20th. I've been very sick. I have told Marcy. She demanded the paperwork next day and told me, I don't know, or IDK, if you can reschedule my court date. I have to ask, she said, and that's wrong by law. You have to. I'm still very sick. And also some very, very serious things happened taking care of regarding my job with 2 or more employees that did identity fraud and had taken all my money. It's in the process of being handled. Also, the court needs to know my mother, Chris, calling police saying I hit her. That's a false report, but I had the police called that day to tell them everything going on. And I have got justice from not one officer. I'm tired of everyone lying and calling in on me with the most ridiculous things. Even I do biting, but sit at home until my mother kicked me out. Now I'm homeless. I want to know why I get cops coming to my house every single time a person calls or makes a lie up, any type of thing about me, period. They're at my door ready to put me in cough, period. Just like when I was, the rest of my mom lied and said I hit her. That's the other sentence, period. I was sleeping when I was arrested, period. There's no proof, nothing, period. I don't understand how that's fair, period. I'm being harassed by police and I want to have it stop, period. This is ridiculous and I'm tired of it. I'm to the point where I don't even want to be here anymore. I'm tired of everyone, family, the city accusing and treating me terrible. It's not fair. I want to have a call from the main person. I'm able, yell, speak to the judge personally. That'd be great. Can you guys please get a hold of me? Because last time I got there, nothing was ever mailed to me and no one ever returned my phone call, please and thank you, period. Have a good day. That is the email that you sent in October 23rd. The response to that, ma'am, was that you either needed to post a bond, and if you did post a bond, then we would recall the warrant, or you could walk in.
I apologize. I didn't get it.
Ma'am?
Check my email.
Stop. You sent an email. You should check your email. And you didn't do that. So don't try telling the court now that you were trying to come into court. So, because you just said that you were in the hospital. Didn't you say you were in the hospital? That's why you missed court?
Yes, I was.
Okay, not anywhere in this email does it say you're in the hospital. Your credibility is about nothing with this court, ma'am. You see that right there. Okay. And so, counsel, as to bond.
Your Honor, just any leniency this court to consider. I believe that my client obviously realizes that there are consequences. She's not appearing in court. She's experiencing them. So we just ask for anything which would potentially allow her to get out of custody, or at least a 10% cash surety provision.
I do have a job that I'm supposed to be checking up on that, it's at a dental office. I can't check it then at home at my phone. You know, I lost a lot. My car got totaled September, a day before my birthday, and my whole bank account got frauded. I'm trying. It's just, I don't know, man.
Ma'am, what I hear is a bunch of run-on sentences with a whole bunch of excuses that you think that are just coming into your head at the particular moment. That's what it sounds like to this court. You want to try to throw everything in to see if any of those excuses sticks. Where do you live, ma'am?
974 Eureka, Wyandotte.
Who lives there with you?
Just me and my mom.
Right. Well, your mom's the victim in the matter from just last week. So you won't be returning there, I can tell you that. So where else are you going to live then, ma'am?
I don't know.
What's that?
I don't know.
And who's the victim on the matter that you're currently on probation for?
What victim are you talking about, man?
The assault case in Wyandotte.
I'm sorry,
I don't know.
the jail,
I don't
the
know
jail review. Let me clarify, the jail review.
what assault you're talking about.
For the jail review case.
What does that mean? Oh, it's not
The
an
assault that I'm
assault.
talking about, ma'am, it shows on November 13th.
Yeah.
You have a charge of assault and battery.
How am I charged with assault and battery when I was never arrested for it? I wasn't even home.
Well, ma'am, let me just say this. The police report indicates they were dispatched to the home in regards to a domestic assault. You left the location prior to the officers getting there. And so then they issued you a citation, ma'am. Or I'm sorry, they got you a citation. A warrant was signed for that.
Against who? My mother with stage 4 lung cancer, dying? Why would I hit my mother? And I was not even home. How is that even illegal? How is that legal? I wasn't even home and I got issued an assault charge because me and my mother got in a fight and I left because I didn't want to argue with
I wouldn't, don't talk about the specifics of the case, miss.
it.
Where is it that you say that you're working? A dental office?
I have a dental office interview coming up this week, but I was working at Packrate and I had 2 individuals bank fraud my account and I followed up with Ecorse Police and it's still going with that ongoing investigation. At Packrate, I was working. They drained my whole bank account, my bank
Okay,
account.
so you don't have a job that you're working, you have an interview.
I was working last month, but I have an interview coming up this week. At a
With the
dental
dental
office.
office. Okay,
That's me.
okay. And so are you out on bond in any other jurisdiction?
No, ma'am.
Have you ever failed to appear in court for any reason
No, ma'am.
other than the jail review here?
No.
And
I promise you, ma'am, I'm trying to get my life together. Just I really, my family has been really.
I cannot understand what you're saying, ma'am.
Ma'am, I'm really trying to get my life together. My family and us been really under a lot since my dad committed suicide. I know what I've done. And I'm just asking if you're willing for me to get this opportunity to get this job and let me get my life back on track. I will not come to court.
Excuse me, who was the victim in the matter out of Livonia?
Livonia.
Yes, the stalking. Who was the victim in that matter?
That was my ex-girlfriend, and that wasn't even true.
Okay. Who was the victim? Who was the victim on the matter from Wyandotte that ended up being over at Third Circuit Court? Assault with a dangerous weapon you pled no contest to.
It was my brother. My brother lied against me in the police report. That's when my dad committed suicide.
And then who did the prior domestic violence you have, ma'am? Who's the victim in that matter? From 2018. Who was the victim that time? Was it your mom?
No,
Who was it?
I'm not sure. I don't even remember recalling that.
Okay, given all the pending, the matters on your criminal history, the assaultive nature of your criminal history, the assaultive nature of 251612, and the matters that are pending currently on the 2015, I'm sorry, the 251614 matter with Ms. Jakubiak, the court has some serious concerns. Detective, would you like to address bond?
Your Honor, I do have some concerns about the proximity of the defendant's address and where the incident happened, the victim's address. So I would recommend a GPS tether. And obviously no contact with any victims or potential victims or witnesses in that case, in the felony case today. And I would also recommend a $25,000, 10% cash bond, Your Honor.
All right, the court's going to note on 251612 for the reasons this court stated on the record, as well as the concern this court has for Ms. Zamorski appearing in court and for the safety of the community. The court's going to order a $10,000, 10% bond on 251612. On 251614, the court's ordering a $50,000, 10% bond with the following bond conditions. You're not to have any contact with Dana Jakubiak or Gloria Zamorski. That's phone contact, text message, email, social media, third party, anything of the like. You're not to return to the premises at 974 Eureka nor 1110 Sycamore. You may return to Eureka, the Eureka Road address, one time accompanied by a police officer to pick up your personal belongings. You're not to possess or consume any alcohol or drugs unless prescribed. You're not to possess or have access to any firearms or weapons. And you are not to be released without GPS tether through the Wayne County Jail. I'm sorry.
So what, my mom pressed charges on me? I can't even talk to my own mother?
Nope, sure cannot.
Thank you, Your Honor.
You cannot talk to your mom directly through a third party or otherwise. Not through writing, not through text message, nothing, no contact.
Thank you, Your Honor.
Thank you, Judge.
Thank you. And just for the record, on the 25443, the court's recalling the warrant and we'll set this GO review also for November 25th.
And let's see, back on the record with Kevin Pianozek. Is that close?
Yes, sir.
Okay, and then Warren Love.
Yes, sir. I'm here.
Okay. I asked you once before when I snuck in on you. Has there been any resolutions at all?
No, sir.
No? Okay. Well, both of you, Mr. Love, can you get on Zoom? I mean, on video?
I'm sorry. You're not able to see me, sir?
No, but if you can get on it, it would help. But if you can't, we'll just leave it.
Okay. Well, I can actually see you and I can see Mr. Kevin, so not sure what the problem is.
Huh. Okay. Well, just leave it that way. We'll maybe we can. It's getting late in the day too for both of you as well. Let's
okay.
Let both of you raise your right hands.
All right.
Mr. Love, you got your hand raised?
Yes, sir.
Okay. Do you swear from the testimony you're about to give will be the truth?
I do, sir.
I do.
Okay. And Mr. I apologize. How did I pronounce the name again?
Pianozek, sir.
Pianozek. It's easier if when you say it than when I'm looking at it. Pianozek, this is your claim for, it says breach of contract, or it's, I believe it was $7,000. Breach of contract. The other parts are, I think we went through this last time, for harassment, intentional infliction of emotion, distress. I think those are kind of out. The breach of contract, and I asked for a purchase agreement originally because Mr. Love was not here either. Where's the breach of contract? Help me out with that.
we were supposed to close on the house on September 12th of 2024.
Oh, 24. Okay, last year. Yep. Go ahead.
And there was, from the purchase agreement there. There's also a letter there from the title company that supports from Tim Burgess, the owner of the title company, that we're supposed to close on the 12th, and he did not show up until the 13th. On page number 5 of the exhibits. Number 6 is from the real estate agent that was selling the house and owner of McNamara Properties that we were supposed to have closed on the 12th.
Okay.
And then on page 7 is from the real estate agent for the condo that I was purchasing that we were supposed to close on the condo. And he did not show up for the closing. He was demanding $3,000 to put in escrow because he wanted to redo the floors after the whole contract was done and signed, just a matter of hours before we were supposed to sign, or he wasn't going to show up. So my real estate agent tried to talk to him about showing up for the thing. And she talked me into putting the $3,000 in escrow because his agent was going to put $1,400 in, but I was putting in $1,600 in to get him to show up to the closing. And then he still didn't show up for the closing on the 12th, which I was supposed to close on my condominium on the 13th. And I had all the people lined up. I had my 2 nephews with their 2 pickup trucks, and I had my son-in-law and my daughter and my 2 grandkids were all going to be there on the 13th with their pickup truck, all to help me move out of the house. And because he didn't show up, I could not close on the condo on the 13th. I had to wait until the following Monday because he didn't show up until that Friday afternoon on the 13th to close on the condo. And I incurred all the expenses on that last page of this sheet because he did not show up for the.
Let me catch up to you right there then. So is there something in here that shows me there was a closing date for the 12th?
Well, the closing date was supposed to be the 11th, but then that's when he started his on the purchase agreement on the very first page of the purchase agreement on the bottom.
I see. Yep, that's where you're catching me
on
up.
section 6 that we were supposed to close on the 11th. That's when he started. He originally started out demanding $2,800 to redo the floors, and then he decided on the next day that he would come on if we raised it to $3,000.
Okay, so hold on right there for me then. So we got September 11th. How did we come up with the 12th then? Was there some discussions?
Because he talked to my real estate agent and said, I'll show up tomorrow if you raise it up to $3,000, the amount of money that you're going to pay to redo my floors.
Okay, so on when was the $3,000, I guess, that you had put into escrow?
We ended up putting that into escrow on the day that we ended up signing the paperwork on the 13th.
Put in escrow on the 13th of what?
Of September of 2024.
Okay, so how, if you agreed to $3,000 and the escrow wasn't put in till the 13th, where's that breach then?
We were supposed to close on the 12th. He promised that we'd give them $3,000. He would be there on the 12th to show up for the paperwork to sign so that I could close on my condo on the 13th because we were using the money from the house to pay for the condo.
Yeah.
And because he didn't show up on the 12th, then on the 13th, I could not close on my condo.
I understand that. But then it sounds like, well, you know what? I'm going to agree to putting money in the escrow on the 13th. That kind of modifies what the time period is.
Your Honor, can I assist in straightening this out, please?
Oh, hold on. Let me just hear from him on this part.
All right.
And then I'll let you. So how that kind of modifies that time period to the, that closing date, because if you're putting an escrow the 13th, that tells me, listen, there was a new agreement that you're putting it in as part of this
Well,
Sal,
we had agreed to put it in on the 12th, as if you look at the letter, exhibit 6 from
I know, but if you didn't put it in till the 13th, right?
well, we put it in on the 12th. On the agreement, we agreed to put the $3,000 in escrow
On the 12th,
on the 12th.
and did you put it in on the 12th though?
Yes, it was put in on the 12th.
Oh, where did I get the 13th then?
Well, he did not show up until the 13th to.
Oh, that's when he showed up.
He
Okay.
did, throwing my whole timeline off of when I was supposed to be able to close on the condo.
Yep. No, I understand all that. Yep. That's okay right there. So you actually put it in on the 12th.
Yes. And there's
Okay.
a letter there, number 6 on the exhibit from the owner of, McNamara Real Estate, that the money was there and that we were there to close on the house, and then he just didn't show up.
Yeah. Okay. So stop right there for me and we'll come back. So, Mr. Love,
Yes, sir.
is it true that you did not show up for closing on the 12th?
Your Honor, I am just totally confused about what Mr. Kevin is talking about. I can assure you, well, first of all, I'm happy to answer your question, but first of all, I'd just like to say, I have no idea what he's talking about. Everything that I did was according to the instructions I was given by the escrow officer and by my real estate agent as far as the time to show up. As Your Honor, I'm sure you're well aware that if you sign an escrow, you have to be there at a particular time that they tell you to be there. I'm not sure what date Mr. Kevin signed his escrow papers, but I signed mine at the day that I was told to be there. And I believe he said earlier to me a while ago that he signed at some company on Hill Road. But the escrow company that I signed was on Saginaw out in Grand Blanc. Now, it might be a different company. I'm not sure. But I can assure you, Your Honor, I showed up at the date and time that I was supposed to show up, and I can prove that by, obviously, I don't have the documents in front of me, but I'd be more than happy to present that to Your Honor to show, and it's just a simple matter of me getting the documents from the escrow company.
Okay, so but you don't have them for me right now?
Well, I don't have it right now, sir, but I'd be happy to get it for you. I can assure you.
We're right now is the time set for trial in this matter.
But Your Honor, if I could just comment on that, I wasn't, I frankly, I wasn't aware that I wasn't prepared for that because I wasn't aware that that was had anything to do with the case that Mr. Kevin had filed against me. Because I'm a little bit frustrated, so I apologize, Your Honor, but I was going by the instructions that was given me by my attorney. And I have an attorney in this case, and he tells me that my case has total merit and that Mr. Kevin has no merit. So,
but sir, I'm not going to listen. Whatever I got in front of me is what I got to go by. So if you got some documents, I'm more than happy to see them, but I got to see them right now.
Well, like I said, I wasn't prepared for this, so I'm not sure.
But you didn't show up on November 4th, and I set that aside because I gave time for him to get the purchase agreement to today's date. When was the notice sent out for this? It was sent out, let's see.
I received it, I believe it was Thursday of last week.
Okay.
Wednesday or Thursday of last week.
Okay. So what did you do from last week to get prepared for today then?
Well, I just, Your Honor, and this is perhaps obviously it's my fault, maybe naivete. But I was basically here to defend myself for this harassment, this intentional infliction of stress and all of that. And I was prepared to do that, and I'm prepared to do that right now, but I can't come up with specific dates about something that I have no documents in front of me for. And frankly, the only thing I can tell you, which is a fact, and that is I showed up at the date and time that I was instructed to show up. That's all I can tell you.
What date did you show up then?
Well, I can't recall exactly, but whatever day we signed up.
So you got to have you can't just tell me something.
Your Honor, if I could tell you the date, I'd have the contract in front of me. I don't have it in front of me. I can't tell you the date, the exact date. I can get it for you. I can assure you, I will assure you, sir, I will get it for you. And if I can't
Sir,
prove my case,
sir, it's right now, that your case is right now. Mr. Pianozek, when did he show up that you are telling me he showed up?
He didn't show up until September 13th at I was told about 5 o'clock in the afternoon. For some reason, he refused to use the same title company as what we were using. And he went to his own title company. That's why the letter number 5 there from the owner of Mason Burgess Title Company saying that we were there on the 12th. He did not show up on the 13th.
I'm sorry. I gotta say something about that. I didn't choose the title company, Mr. Kevin. You're mischaracterizing the whole thing. The title company apparently was chosen by the escrow company. I have no idea who chose the title company. So you're saying that I chose the title company and I showed up at 5 o'clock. All of these are just pure fabrication, sir, and you know it. And Your
How
Honor,
is it fabrications when there's letters here from the company owners of 3 different companies stating that you were supposed to have been there on the 12th and you didn't show up?
That is not true. You show me.
It's everybody's word against yours. You lie all the time to do what you want, and you try to manipulate the system.
Mr. Kevin, I never accused you of lying, sir. I said that you're making a mistake in your facts, and I really resent the fact that you accuse me of lying. I'm not lying. I would like to have an opportunity, Your Honor, to explain the case and put it in perspective, and hopefully, I'll have an opportunity to do that.
You are right now.
All right. Now, I would like to just go back and put this, like I said, and I'll be as brief as possible and be happy to answer all questions. But this whole case stemmed from the purchase of the house from Mr. Kevin. And at the time I purchased the house, Your Honor, there was an issue. Mr. Kevin signed a document, an official disclosure indicating that there were no issues with the house. There was no issue with mold. There was no issue with flooding in the basement and so on. So when we signed the document, the escrow documents, Mr. Kevin asked me to rent the house back to him for a month in order to give him time to find another place, which I agreed to do. And the fees were supposed to be broken down to equate with whatever the mortgage payment was for the amount of time that he was there. Now, I believe he was there for 30 days. So that money, first of all, the $300, the $3,000 that he's talking about, I have no knowledge of that. Mr. Kevin, never deposited any money from his hands to the escrow for carpet or whatever he's talking about. That money was deposited by the real estate agent. So anyway, out of her proceeds, by the way. So anyway, to go on with the explanation, sir, and I apologize because I'm a little bit frustrated. But so what happened was Mr. Kevin stayed at the house for about 30 days, and then he moved out. So the next morning, my real estate agent called me and said, well, let's go do the final walkthrough. Well, Mr. Kevin wasn't here. So we walked through the house and we found flooding in the basement. We found mold in the basement. And my agent took videos of that, and she took still photos of that. And she presented this information to Mr. Kevin. Mr. Kevin denied the whole thing, denied that there was any such thing. So I ended up having construction companies come out and fix the flooding and and get rid of the mold. I had to do that right away. So I contacted Mr. Kevin about the rent. He refused to pay the rent. I had to contact a lawyer, and the lawyer threatened, but sent him a letter, which I have a copy here in my hand, and I'm sure Mr. Kevin has a copy, sent him a letter explaining the problems with the basement, the breach of disclosure information, the fact that he didn't disclose the information accurately, and that based upon that and the fact that I had to pay for all of these repairs and all of that, he asked Mr. Kevin to negotiate a reimbursement of $8,332. Mr. Kevin refused to do that, and Mr. Kevin then turned around and filed a small claims against me for these charges that you just spoke of. This breach of contract, the harassment, and intentional infliction of emotional distress. Now, I spoke with my attorney about, excuse me, I spoke with my attorney about that, and he said, well, yeah, obviously the case has no merit. He felt that Mr. Kevin filed the case for retaliatory purposes, and he suggested that I have the case moved from small claims to general court in order for me to be able to bring in witnesses and also to have legal representation if I so chose. So I asked him to agree with me to put that matter on hold until we have this hearing today, this trial today, and then we'll see how it goes from there. And so he
So here
just
we are
suggested,
today.
well,
Okay, so I'm gonna make some decisions today then, because today's the time set for trial.
Your Honor, if I
I'm
may.
sorry, sir.
Sir, hold on just a minute. Let me just kind of go through some of the documents I have though first, okay? I got the document, Mr. Pianozek, I'm gonna ask you first. It says contingency removal. It's dated September 12th, 2024. For the property at 1438 Hickory Hollow Drive. Sellers are yourself, and it looks like maybe your wife, maybe?
Yes.
Perry? Okay.
Yes.
It says buyers Warren Love. It says in reference to the sales agreement dated August 9th, 2024 between the buyer and the seller. All subsequent addendums and that to that agreement from the property stated above, it is agreed that the buyers and sellers that all contingencies pursuant to said agreement have been met, resolved, or removed to satisfaction of all parties. Further, the undersigned agreement to indemnify, save and release Howard Homes for You and AAA McNamara Properties from any responsibility. It looks like everybody signed this document. So this was dated September 12th. Mr. Pianozek, did you sign that document there?
Yes.
Okay. And Mr. Love, it looks like you signed it as well.
Well, if my signature is there, sir, I'm sure I did, but I just don't remember exactly.
Yeah, well, it's got a signature that looks like, let's see. It's got your signature. It's purported to be your signature on the 12th.
Well, I don't have the document in front of me, so I'm assuming it's official. That's all I can say. I don't know.
Okay. Mr. Pianozek, was Mr. Love there when that was signed in front? Were everybody there, or what? How'd that get signed?
Everything got signed via DocuSign because he wouldn't come to the offices to sign anything. What he is talking about is he's trying to say that there was water damage in the basement. If the very first page, very exhibit number one was a seller's disclosure agreement.
Yeah, but we're getting kind of past that. This particular document says any contingencies are released.
Correct. He took and he had his house inspection, and the inspector had a whole bunch of things that they needed fixed. We fixed everything, sent them pictures and videos of everything that had been fixed, and then he signed a contingency release saying that everything was fixed to his satisfaction and that he was ready to buy the house as is. And he signed papers in here too, that the papers are in the back that state that he is buying the house as is, where is, and that he was happy with everything as is.
Okay, hold on. What exhibit is that one then?
Number 9.
9. Exhibit 9.
And number 10, when he signed the final bill of sale for the house.
Let's see here. 8.
What he's basically doing is he wanted to remodel a basement, and he's trying to get me to pay to remodel the basement. Just like he extorted us into paying to put hardwood floors in the house after the whole deal.
No, I resent this this characterization of extorted me. He did this, he did that. Can we please just be honest and be gentlemanly and treat people, okay, just, can
Yeah,
you just
let's just
dispense
kind of
with
leave
that
it.
because it is totally unnecessary
Yeah, let's
and
just leave
totally
it to what I,
untrue.
let's just leave it to whatever questions I ask, okay? And let me just see what I got here. Wait. Open. Oh. Oh, here it is. Here's 10. Okay. Here they are. Exhibits 9 and 10. It's got again Warren Love's signature on it. Buyer accepts property as is. That's dated September 12th as well. Date of closing September 12th is exhibit 10. That's got everybody's signature on it. It says okay, that's for goods and chattels. So the one for the property itself is exhibit 9, it looks like. And it's also, each of these have Mr. Love's signature, Mr. Pianozek's got your signatures on it, as well as your wife's. Is that true?
Yes.
Okay. And if the documents are dated September 12th, is that the date that you recollect these being signed on, or is this some other date?
Those were all signed via DocuSign on the 12th. Yes, sir.
Okay. Okay, that's all. Yeah,
That
that's
was
what I need.
Yeah, that was the
So-
date that he was supposed to show up at the title company to sign for the purchase of the house.
Okay.
As per exhibit 5 and 6.
Gosh, what a,
I guess I'm missing one big question too. Was the property finally closed on? Is that what happened?
On the 13th, it was finally closed on. Yes, sir.
Yeah, and that's where we get the other closing document, wherever I saw that. Mr. Love, can we agree that it was closed on the 13th?
it sounds about right, Your Honor.
Okay.
But Your Honor, I gotta be honest, I really don't know what his complaint is. I mean, I'm hearing a lot of things. Is this what he's talking about? Is that supposed to be the breach of contract issue that he's talking
Well,
about?
that's okay. Hold on. I'm gonna get to that right next. So if Mr. Pianozek, from your side, if all contingencies were removed and you signed that and Mr. Love signed that, how did we get a breach of contract then?
Because he
For
was
just
supposed to
not showing up?
He was supposed to show up on the 12th to sign the final paperwork at the title company, Mason Burgess Title Company,
Yeah.
for
why,
the final purchase of the house.
so why didn't you have that put in those documents too, saying, hey, listen, by the way, though, there may be some damages for failure to appear on the September 12th date?
I'm sorry, what, Your Honor?
Why don't we have something in these documents that say, except for the fact that defendant, Mr. Love, did not show up on September 12th, there may be some expenses due and owing to me for failing to appear. Why don't we have that?
Well, I mean, normally people show up for the closing.
I
Otherwise,
know,
he was on a risk of
I know,
losing.
and yeah, I agree with you. He didn't show up, but the documents that you just provided me, these contingency removals, don't show anything about him not showing up, and you should have some expenses for those things. How do we get that?
I guess I'm not understanding what you're getting at there. I know on exhibit 6
Yep.
was the letter from the the AAA McNamara from Hilda McNamara, Exhibit 6, that he was supposed to have been there on the 6th. And on Exhibit 7 is what the letter from the real estate agent for the condo company from Real Estate with a Cause had.
Okay, hold on. So let me catch up to you right there. So I got Exhibit 6, which is from, looks like AAA Independent. Gosh, it's kind of light.
From AAA McNamara
It's
Properties.
McNamara Properties, yeah. Okay, let me just read this one real quick. Property was listed, marketed, scheduled for 7/12. Okay. Not okay. Okay, I see. So, okay, so September, okay, this Exhibit 6. Yeah, it's
Can I
clear
make a
on
brief
that.
comment, please?
Oh, just a minute. Let me read this
All right.
first. The property was listed. Closing was originally scheduled for September 12th, which would make sense with the other documents. Kinda. I mean, they were signed September 12th, but maybe it was scheduled later on in the day. When was the closing scheduled for on the 12th?
At noon.
Okay. Okay. On the day of the scheduled closing, the buyer did not appear, citing concerns regarding alleged undisclosed water damage. So, Mr. Pianozek, on this date, I guess it's the September 12th date. Is that when you put the $3,000 in escrow?
Yes.
Okay, so I see that. And that was in good faith for what purpose?
In order to get him to show up at the closing so
totally
that we
not
could
true, Your
facilitate
Honor.
buying our condo and moving in over into the condo over the weekend.
So was
That is totally not true, Your Honor.
Okay, so
he, first of all, the money, the $3,000 came from the proceeds of the sale. And the reason the $3,000 was put in on hold, it was for the rent he deposited rent. He agreed to deposit rent in escrow for the period of time that he was going to be staying here at the house. And so now there was a $3,000. There was an additional $3,000. And I think he mentioned something earlier about that. That was put into escrow on my behalf, which was negotiated in the sale of the house. And the purpose of that was to replace the carpet damage in the house. So I'm not this $3,000 that Mr. Kevin is talking about was the $3,000 that he was required to put up according to escrow to rent the house. So, and that money was put up not in advance. It was put up. It was taken out of the proceeds when the deal was closed. So, Mr. Kevin is not really giving straight information here about this.
That is not true, Your Honor. The $3,000 is separate from the purchase price. I mean, the rent agreement of the house was held by the escrow company and was later released to him. We were required to pay a rent of $85.43 a day for 30 days.
right. And I see that there's a separate hold on, there's on paragraph 21 of the purchase agreement, there's a $3,000 deposit. Buyers and sellers, the buyers herewith deposit. There was $3,000 deposit from the buyer for earnest money down. It looks like that was what that was for. And then there's also money, Mr. Pianozek, if you're telling me that was put in escrow for rent.
Yes, the title company also held out the money for the rent. And that is in part of Exhibit 8.
Exhibit 8, okay. Let's look at 8. Here's 8. Occupancy escrow agreement, okay. I see that. The retained escrow rent is. Actually, it looks like it wasn't 3,000, it was 2,562.
That was a separate amount from the $3,000. The $2,562.96 we were required to leave with the title company to give to him for the rent if should we stay there for the full 30 days.
Yeah. Okay, so you're just not rounding up to this other 3,000. This other
No, sir.
3,000 is okay.
Well, the other 3,000 is a completely separate amount of money.
Sir, Mr. Kevin,
what the rent
that is
money with the money for that he got from us for the escrow.
Oh, okay, so Mr. Love,
Yes,
what
sir.
is it you wanted to tell me? It sounds like there's a couple of $3,000 maybe, but there was.
Well, yeah, and Your Honor, again, Mr. Kevin was required to deposit money in escrow to cover the rental for the month that he was here. Now, the other $3,000 that he's talking about it had nothing to do with him. He had no issue with that whatsoever. It was in order to make the deal, to consummate the deal, the real estate agent, my agent, as a matter of fact, decided, well, I tell you what, I'm going to give a part of my fees to make this deal go. If it satisfies you, I'll give part of my fees so that we can take care of the carpet issue, because that was one of the issues that we negotiated when I bought the house. I don't want to buy the house with the carpet being in the shape it's in. And so my agent said, well, in order to.
Where's that in writing? Where am I looking for carpet?
It's all in the official document, sir, in the closing documents.
You gotta help me out. Mr. Pianozek, is there something about carpet somewhere in here? You seem to be a little bit more.
What he is saying is not true, Your Honor. The $3,000.
Hold on, is there, do you know of anything in these documents that says 3,000, something for carpet? Is there something in here that I need to look at?
That was Exhibit 6, is the $3,000 escrow that he wanted held back.
Oh, that's part of that 3,000?
Correct. In order to get him to show up to sign for the house, because originally, it's a long story. It started out as $1,000 because he didn't like the way the landscaping, the sloping was around the house. So we agreed to put $1,000 down towards he was going to redo the landscaping and sloping around the house because he was afraid water might get into the house. Then a couple days later, then $1,000 wasn't enough. He wanted $2,800 because he wanted to redo. He was deciding not going to worry about the landscaping around the house. He was going to want $2,800 to redo the flooring in the house. So then we ended up we were forced to agree to that because we were trying to close in the condo so we could move in. Then he decided that the $2,800 wasn't enough, that he wanted $3,000. And that's what were forced to give him to try to get him to show up per document 6. And he still didn't show up for the closing of the house on the 12th.
Okay.
Your Honor, please allow me. All of that, Mr.
Kevin. You're not helping me out any. What is it now?
Well, all right, whatever. I can only tell you the truth, sir, and I'm prepared to back up my statements, which I did with my attorney. I wasn't aware that I needed to bring the escrow papers with me for this particular trial, and because I had no idea.
To that, there's a court notice that says today's non-jury trial date, Tuesday, November 18th, 8:30. It was issued November 4th, 2025. You had that. Today's the date. We're not going to go back in time and complain about all that.
Well, sir, you know what? I pardon me, but I'm just frustrated with this whole thing because what I'm hearing is that Mr. Kevin is sitting here just spouting off a bunch of nonsense that he making claims that he's not even being asked to support. He's just making all of these wild accusations, and then none of it is true. And the fact that I don't have the closing documents in front of me obviously has been held against me. So I presented all the evidence necessary to file my case against Mr. Kevin to my
where is
attorney.
it? And where
I'm
is
sorry?
it? Where is it? Your documents.
I just told you it's in the it's they're upstairs in the
No,
in the
why don't I have them today?
because I didn't know you needed them, sir.
Sir, today's the trial date.
Sir, you know what? You see, and this is
No.
this is my confusion. I wasn't aware that we were going to be here. I didn't realize that we were going to have a trial over the escrow thing. That's
Sir.
why I didn't bring the escrow papers with me.
You're the one that
So-
asked for the trial.
Pardon?
You're the one that asked for this trial.
You're the
You're
one
the
that
one
filed
that
the
filed the
case, sir. I
motion to
didn't
ask
ask for the
this
trial.
It's all under the breach of contract. That's all I'm dealing with today is this breach of contract, and that's what was filed originally as a small claims. That's where we're at.
Well, I don't know what the breach of contract is that, and frankly speaking, I disagree that Mr. Kevin has proven a case about breach of contract. I never breached any contract. And, so.
All right. So
I
we're
mean, there
down
are
to-
so many other issues involved with this
So-
case that hasn't even been talked about.
Sir,
And,
we're on his part of this case right now still. Let's get back to just the closing date then. Looks like it was scheduled for September 12th, but the closing actually took place September 13th. Mr.
Yes, Your Honor.
And Mr. Love, is that true?
like I said, if it's,
Is-
yeah,
is
that
it
sounds
true or not
accurate.
true? Or if you don't know, I'll take I don't know.
It sounds accurate. I don't have the documents in front of me, but it does sound accurate.
Okay. So if the agreement date was the September 12th date, you guys both ended up closing on the 13th. I see a bunch of documents that say property sold as is, contingencies all removed. And that gets us back to the real crux of the complaint is what Mr. Pianozek is asking for is reimbursement for the delay in the closing, right?
Yes, sir.
That's where we're at. So on this delay of closing, when were you closing on your other property?
On September 13th, we were originally set to close on that per document 7.
Okay, so on document 7, yeah, I got that. So where on your purchase agreement or any other documents that says timing is of the essence, I must close by September 12th? Where's that?
We did not feel the need that we had to put that in writing, that we had to close, that he was there. We had the contract for him to show up on the 12th to close. So then we set up our closing date on the 13th so that we could purchase the condo and then move in over that weekend.
Okay, so we got nothing that says time is of the essence. That kind of hurts you a little bit. But it did not close on the 12th like it was recommended, but everybody closed on the 13th.
Yes.
And on the 13th, do we have any documents, Mr. Pianozek, that say, hey, listen, there's going to be some expenses for late closure on this property because I was harmed by having to close on another place later than it should have been.
I do not have anything stating that I was going to incur damages as of that date. No, sir. I
Okay.
did incur damages because of that.
And that was going to be my next question.
But
What
I could not
damages did you actually-
foresee in the future, could not foresee on that date that I was going to incur these damages because he wasn't going to show up on the 12th.
Okay, so what damage did you incur because of the late closing date?
Okay. Because he didn't show up for the closing date, I had to rent a U-Haul truck for $85.43. These are the documents. My receipts are all 17, 18, and 19 exhibits. I had to rent a U-Haul truck for $85.49. For the bigger things that I could not move because I did not have my help there then, was I had to rent 2 men in a truck for $773.75. I was forced to pay rent for those days because I couldn't move at $85.43 a day for the 12th, 13th, 14th, and 15th at $85.43 a day for a total of $341.72. There was a filing fee here at the court of $70, a service fee of $40, and the escrow of $1,600 that he was forced me to give him to show up to close on the house, for a total of $2,910.96 on Exhibit 20.
Okay, so the U-Haul truck, I guess I don't understand. You would have had to move anyways. How did that damage it because it was late?
Because I had on the 13th, my son-in-law, his wife, and my 2 grandkids were going to come over with their truck. My 2 nephews were coming over with their pickup trucks all on the 13th.
Okay, did you pay them at all?
I did not pay them. They all took the weekend off of work in order to help me to move.
Okay.
And
so again,
because he didn't show up,
wouldn't you have to?
I couldn't close on the condo till on the following Monday, and they all had to go back to work, and then I had nobody to help me move.
Which you would have had to have somebody move anyways, right? But you had family, which was lucky.
Right. I had my
which
family
nice.
was sit there for the entire weekend ready to help me move for that Friday, Saturday, and Sunday. They all volunteered to come over and take the time off of work to come over and help me move on that weekend. And because he didn't show up until that Friday afternoon, I couldn't close on the condo until the following Monday. So I couldn't move into the condo over the course of the weekend. And that's how I incurred these expenses that I would not have normally have incurred these expenses if he would have just simply showed up on the 12th.
Your Honor, may I come in, please?
Yeah, just a minute. Let me just finish up with this last thing. So really all of these items are, well, other than the rent that you paid, the $85.43 per day, and that's rent to Mr. Love, right?
Yes.
Okay, so we'll get to that one, but the other ones are all moving expenses, correct?
Yes.
Okay.
I would not have incurred those expenses though if he would have showed up on the 12th, because I had all ready to help me move for free.
Okay. Yeah. Okay. All right. So now we're getting to the bottom of those things. So did the rent, the 3 days worth of rent come out someplace?
Yes, it came out of the escrow agreement on page 8.
Okay. 12th, 13th, 14th, 15th. Those are the dates for that, it looks like.
Yes, sir.
Okay. Okay, and then Mr. Love, why don't you just deal with what I've just asked about? And
all right.
You want to add on that part?
Yes, Don, thank you, Your Honor. Your Honor, when I agreed to rent the apartment, the house back to Mr. Kevin, it was done so at his request to allow him a time to find a place to move to. So he had 30 days. He stayed in the house for 30 days. There was no issue about 2 or 3 days or whatever. So he had 30 days to make a decision and to find a place and all of that. And he stayed here for that period of time. And when he moved out, then we settled the amount of money that was due for the rent. And like I said, I don't want to repeat myself, but he refused to pay that rent money, and that's why I ended up having to get a lawyer in order to get him to pay the rent. It went on for 9 months, sir, and that he refused to pay the rent. And the other issue, he mentioned some dollar figures there, but one of the other issues was that he was required, part of the rental agreement, to post $1,000 for possible damages during the time that he was here. Now, when he moved out, my real estate agent and I, when we did the walkthrough, we found damages on the floor near the entry door. And my agent took pictures of that, spoke with his agent about it, and his agent referred it to him our request for him, actually, we had some estimates and referred that to him. And so he refused to address that issue. Now, the reason it took 9 months to get the rent money is because the escrow company, refused to release the rent money because he refused to sign off on it because he said it wasn't going to sign off on it unless I relieved him of the issue regarding the damage. So it was finally my attorney wrote a threatening letter to the escrow company and said, we're going to have to sue you guys. And Mr. Kevin still did not release the rent money. He hasn't released the rent money to this day. But the escrow company went ahead and paid it anyway because they didn't want to go through any kind of litigation behind it. And they just sort of threw up their hand. So, and went ahead and paid it anyway. Now, just one other brief comment. He spoke earlier about this has been this AAA real estate company, and they said that I didn't show up on time. Well, first of all, the AAA real estate company, I'm assuming he's talking about his real estate agent. Real estate agent didn't set the time of the escrow. That was set by the escrow company. And so I reported to the escrow company at the time that I was supposed to show, and we signed the documents at that time. There was never an issue, Your Honor, about any of this until just recently after my attorney filed a complaint. Then all of this stuff that, he filed this thing into, filed charges into small claims court, claiming that I'm harassing him and all this sort of thing. So that's why I said earlier, it's just simply a matter of retaliation on his part. And he's just making up a whole bunch of stuff. And many of the comments that he's making just totally untrue, Your Honor. It has no merit whatsoever. He's just throwing stuff out there apparently to see what sticks on the wall.
Hey, so let me ask you this, Mr. Love.
Yes, sir.
The days of rent, he's got them listed dates for the 12th, 13th, 14th, 15th of September of last year was $341.72. Did you receive that money?
320. I don't recall receiving any money of that sort,
That
sir.
was the rent, the time that he was renting the place.
No, sir. I didn't. I'd never received any rent money other than actually I received part of the rent money because part of it was taken out by my attorney to represent me. So I actually lost $1,000 on the deal because that's what I had to pay the attorney.
Okay, hold on though. But you said that was you got something for rent though. It sounded like.
Correct.
You just said you paid your attorney. Is that true at least? Did it come
in order
out
to
of
retain the attorney, I had to give him some money. Yes.
Yeah, and that came out of that portion that was sitting there for rent that you were to receive.
Well, when I received the check for the rent, I paid my attorney $1,000.
Okay, so you did receive the rent money.
Yes, sir. 9 months later.
Okay. All right.
And by the way, Your Honor, I never received the money for the damages to the house, and we sort of gave up on that. We, meaning my attorney and I, sort of gave up on that because there was a technical issue in that my real estate agent informed Mr. Kevin, but according to the escrow company, my escrow agent never informed them or never submitted a request or demand for the $300 for the damages. So based upon that technicality, my attorney and I said, well, we'll just leave that because the only way you can pursue that is to sue the real estate agent and all that. I didn't really want to go through that. So I just said, okay, fine. We'll just forget about that.
All right. So I got one more question for Mr. Pianozek. This amount that you got listed, Mr. Pianozek, what happened? Oh God, you could leave here. Mr. Pianozek, what happened? Got to unmute.
I'm sorry, Your Honor. I don't know what happened. I was there and all of a sudden it just went black and disappeared.
Okay, so I know I go back through everything. The last, I guess the last question I got for you is the escrow that you got listed as an expense, 1,600. What is that?
That was part of the money that he forced us to give him to show, in order to show up
Okay,
to
that's
sign
out
the
of that
paperwork.
out of that 3,000.
Your Honor,
Yes, sir.
please, Your Honor, I resent the fact that that would be tantamount to extortion.
Yeah.
If I did,
Sir, hold on. I'm not, I just want to know where he's coming from with that, okay? That's it. That's all it is, just so I know where that amount he's asking for out of that.
And I know he was talking about us not paying rent, but if you look at page 8, the rent was already prepaid with the title company in with the title company, and we had nothing to do with that after that fact. It was already paid.
Okay. All right, guys. I think I've heard enough. I'm gonna get off for just a second, make a decision, come back on. Okay.
All right, thank you, Your Honor.
Back on. All right.
Mr. Kevin,
Yes.
you're a pretty good liar, sir.
You're the one that is lying.
You are a pretty good
I
liar.
have documents here from everybody that says you were supposed to have been there. You did not show up. You're saying,
Hold on. I'm gonna put you all in separate rooms if I gotta do that.
you're the one that's sitting there saying that everybody else is lying.
I said you were lying.
I'm gonna, guys, seriously. I'm gonna put each of you in a different room. I expect you're just gonna be whatever room I put you in right now. Okay, we can go back on the record. I hit it. Chance to review the all of the documents that were supplied, well, quite frankly, all of them by plaintiff in this matter, Mr. Pianozek. If you had a chance to review all of those documents and reviewed my notes regarding testimony in this matter, I do find that this matter was involved with the closing on a piece of property at 1438 Hickory Hollow Drive in Flint, Michigan. There was a original closing date stated in the purchase agreement for the I think it was the 11th here.
Yes, Your Honor.
Okay, yep, I need everybody just be quiet right now, okay? No confirmation or affirmation of what I am doing for everybody's sake. There it is. That closing date did not occur. It was then scheduled for the 12th, or at least on paperwork, it looks like it was finally originally scheduled for September 12th. On that date, documents were signed with releases on liability. There's a contingency removal that was signed by the parties. There's also buyer accepts property as is. It was also signed by Mr. Love, and there was also one for goods and chattels. As anything left on that property, goods and chattels, was purchased as is as well with no warranties. Those documents eliminated any contingencies on the property. The property did close on after that date, on the following date, the 13th. We do find that based upon all the documents regarding the purchase of this property and sale of this property, find that there was no clause showing time was of the essence for a closing date by the parties. I find that based upon the fact that both parties closed actually on the property, there's been no documentation that there was leaving open any possibility of expenses incurred for that untimeliness of that closing. Therefore, I find that there was waived at the time and any claim that there was an untimely closing that caused expenses based upon the conversations between the parties as well. For all these reasons, also, there was the list of items that were claimed for expenses, find that the rent was for a time period last year, September 12th, 13th, 14th, and 15th. Again, is what was been argued is resulting from the untimeliness of the closing. But I again, based upon the actions of both sides, find that is waived. The U-Haul truck, 2 men in a truck, those items, there was going to be expenses for moving charges regardless. Again, I understand that plaintiff had family coming in to help. Unfortunately, that didn't occur. But again, giving the lateness of the closing, those were just outside of what the agreements were between the parties. There was going to be moving charges one way or the other. It was fortunate that plaintiff had family coming into town, but given the untimeliness and giving the closing and giving no documentation that, listen, I'm incurring some expenses for the lateness of the closing, I just don't see any cause of action for any of these items. Therefore, the case is dismissed, no cause of action. All right, good luck to both of you.
All right, thank you.
All right, you're welcome. Bye now.